I'm joined today by Louise Clifford from our employment team, and we're going to talk about the impact of the recent TUPE reforms. So Louise, what are the key factors for in-house lawyers coming out of the reforms?
Well, I think the first point is that the reforms aren't as extensive as we first anticipated. That said, there are a number of changes that they need to be aware of. So first of all, we've got a new test for establishing when a transfer-related dismissal will be automatically unfair. We've got a similar change in relation to changes to terms and conditions and when they will be lawful and unlawful. We've got a slightly amended provision in relation to employee liability information. So this is the information that needs to be provided by an outgoing employer to a new employer in a TUPE situation. That needs to now be provided 28 days before the transfer rather than the original 14. The other change to be aware of is that we have a set of measures that are designed to remove some of the day-to-day obstacles to employers, particularly in the context of dealing with relocations and redundancies.
Are there any changes to collective agreements?
There are a couple of key changes. The first really is to bring the legislation in line with the Parkwood litigation and the outcome of that. And what that essentially said was that in a TUPE situation, a transferee won't be bound by changes to collective agreements that take place after the transfer when it hasn't been part of the relevant negotiations. The other change is that there's now a flexibility for employers to agree changes to collectively agreed terms, but those need to take place a year or more after the transfer. The key thing to be aware of there is that there is, as part of the test, this requirement that any new package that's offered to employees must be overall no less favourable than the original terms. And we don't yet know exactly how that's going to be interpreted by the courts.
I understand there's a new service provision change test. What's that all about?
Well, the service provision change test is a test that specifically applies to, or specifically designed to apply to outsourcing situations. Now, the government had originally talked about repealing it altogether, and that's because the test that was introduced in 2006 goes beyond what we're required to implement by the Acquired Rights Directive. What actually happened as the government went through the consultation is that it became clear that actually businesses, rather than seeing this as an additional burden, welcomed the relative certainty that the test provides. So that the test has remained intact and there's been very little change. There is a subtle change to the wording which is intended to reflect where we've got to in the case law, and that is that any activities that are continued after a transfer must be fundamentally the same as those carried on before. But other than that, the test is here to stay.
And can that test apply to framework agreements as well?
It can, yeah. Certainly there's nothing in principle to stop framework agreements being affected in the same way. So activities provided pursuant to an agreement can be capable of amounting to or giving rise to a service provision change. There has been having a couple of attempts in the courts to try and challenge that position, particularly where you have situations where there's no guaranteed minimum level of work. But what the courts have said is that you shouldn't focus too much on what the contract says. You should look at actually what's happening on the ground. And if, as a matter of fact, activities are being carried on by a new contractor in the same way as they were previously, then the SPC test can apply.
And in an outsourcing context, are there any examples where the service provision change test wouldn't apply?
There are, yeah. As a starting point, the SPC test will apply where you've got an insourcing or an outsourcing of services or a change of contractor. But there are a couple of conditions in the legislation which need to be fulfilled. So the first of those is that you need an organised grouping of employees whose principal purpose is delivering those activities. And there's been quite a lot of case law around that test and what it actually means, and certainly perhaps more than initially meets the eye. The other part of the test that needs to be satisfied is this idea that services need to be resumed and carried on in fundamentally the same way. So there are quite a number of situations in which that might not happen. One example being where activities are very heavily fragmented and it's not possible to identify where the original activities end up.
What if you change clients?
Well, that's an interesting one because it's clear that under the legislation, the client in a service provision change context needs to be the same client before and after the transfer of activities. Now, I think the interesting area is what's going to happen in the context of subcontractors and prime contractors, because depending on who the client is in that situation, whether it's a prime contractor or the ultimate client, that could in a particular situation impact on whether TUPE applies or not. And that whole question of how change of client operates in the context of subcontract, prime contract situations, I think is one that we're perhaps going to see more litigation about.
I've heard that there are some short-term exemptions which apply in the context of the service provision change test. How do they work?
There are two main exemptions where the service provision change test won't apply. The first is where the activities are for the provision of goods for the client's own use. And the second is where the client intends that the activities will be carried out other than in connection with a task or an event of short-term duration. Now, we don't have any clear guidance as to what short-term actually means, but it's clear from the case law that it's very much dependent on context, and it actually might be longer than you might first think when you hear the term short-term. So if you are faced with a situation where you think the exemption might be triggered, it's worthwhile looking at the case law on that.
So Louise, in your view, do you think the reforms are working?
Well, I think it's too early to tell. I think a lot of the cases that we're getting through the courts still now relate to the old regulations, if you like. I mean, the changes aren't quite as extensive as we had anticipated, so we're not expecting a wholesale change in the way people deal with TUPE. That said, some of the new tests are unclear in terms of their scope, so we are expecting in due course we'll probably start to see some cases coming through the courts.
Thank you, Louise. That's been really interesting.
Thank you.